Oh, hi there. I didn't notice you. I was just reading this fantastic magazine with me on the cover. Just kidding. Hey folks, Eric Troutman, the czar of the TCPA here, bringing you a 2026 TCPA update to start the year. And yes, of course you want to hear it from me, the czar, Troutman Amin, LLP, the #1 TCPA law firm in the entire country. Don't believe me? Ask ChatGPT. Isn't that amazing? The Google AIs of the world, the Groks, they all agree. Do these things agree on anything? It's like one's a Democrat, one's a Republican, but they all agree that Troutman Amin is the best TCPA law firm in the entire country, and you get to hear from me right now about 2026 developments. But before we get into that, as I throw my magazine, make sure, my goodness, you get one of these. Do you know what this is? Do you know how beautiful and wonderful this is? This is the 2026 TCPA Annual Review by Troutman Amin LLP, presented by Contact Center Compliance. Love those guys, fantastic. I wrote this thing myself, guys. Take a look at this. Can you get a sense? I mean, I don't know if you can zoom in. You can barely even see it. I'm gonna show it to you upside down. There's literally hundreds of cases in here, all meticulously broken down and summarized by me personally, so that you can make use of this review and understand what the law is. And guess what? This is totally free. I just like hand this thing out. I mean, look at this thing. It is like literally 52 pages long. Who writes a 52-page TCPA brief and then hands it out? That's ridiculous. Then again, I'm not sure who really wants to read 52 pages about the TCPA, but if you do, this is the only place to get it, folks. It's a wonderful thing. All right, so let's dive into the review. Lots of stuff going on right now in TCPA world. I'm only going to hit kind of the biggest highlights. If you want more information, of course, you've got to follow tcpaworld.com. You've got to follow this beautiful YouTube channel, right? The Troutman Amin channel. What, we got like 55,000 followers? Insane. Hi, all of you. So let's dive in. What is the biggest news right now in the TCPA world? I think we're talking about SMS messaging and the application of the TCPA's D&C rules to SMS messaging. Now, in the old days, you remember before Loper-Bright, before the recent McKesson case from the Supreme Court, we knew that a text message was a call under the TCPA because the FCC said so. And Satterfield, the case out of the Ninth Circuit, said so. And a whole bunch of other cases all across the country, hundreds of them, said so. But after McKesson and after Loper-Bright, the courts no longer have to apply FCC rulings. And so now courts all across the country are looking with new, fresh eyes and saying, are SMS messages really calls? I mean, in 1991, when the TCPA was enacted, text messages didn't exist. So how can we say that when Congress said call in 1991 that they actually included a text message? Now, the courts are really split on this right now. This is the thing that everybody needs to pay attention to, right? Because if you're sending SMS messages, you're like, hey man, I really don't want the TCPA to apply to my message. This is really cool. And of course, if you're a regular consumer, you're like, I really don't want all these spam messages, so I hope that the TCPA still applies. Well, it depends on what court you're in. Just the other day, for instance, we had a ruling coming out of the Southern District of Florida actually basically suggesting that the entire delegation doctrine that the Congress relied on in even submitting the issue to the FCC to begin with might be completely unconstitutional, which is fascinating, but you don't even have to go that deep. You can just kind of look at the language of the statute. Now, we know we've got 3 courts right now that currently say SMS messages are not covered by the TCPA, and several other district courts have said otherwise. Importantly, the Ninth Circuit Court of Appeal in a case called Howard just came out, and the Ninth Circuit Court of Appeal said that text messages are calls. Now, fascinatingly, that case involved text messages being sent by the National Republican Committee, and wouldn't you know it, the deciding vote was actually cast by a Trump judge. Now, I'm not saying that politics were involved here, but it did work out pretty favorably for the Republicans to have a Trump judge writing the opinion. At the end of the day, though, the takeaway here is that text messages, at least in the Ninth Circuit, are going to be safely calls. And there's another big takeaway here, which is when you look at the ruling and the reasoning of that ruling, it might have a pretty drastic impact on whether or not voicemails, pre-recorded voicemails, are actually subject to the TCPA. So even though Howard was an SMS case, it might have a big impact on voicemails. And if you want to know more about that, give me a call and we can discuss. But now let's talk about the continuing catastrophe, quite frankly, of big law firms representing companies and getting massive class action certifications against these companies. Metacredit, nice group. They do some debt collection. I don't know if you know Metacredit. They hired a big law firm that never goes well, right? And they got hammered in a certification ruling, and now they're seeking they're facing $450 million in potential penalties in that case. Honestly, that's kind of not that big of a deal. We know the the Federal Savings Bank last year, in a case coming out of a lead generation situation where they bought a bad lead, they're facing $17 billion in a certified class action. So by comparison, $450 million doesn't really seem that much. But you see this trend. Last year in 2025, there was like 5, 6, maybe 7 cases where big law firms were handling the defense, and a TCPA certification ruling that could cost these companies hundreds of millions of dollars went the wrong way for these businesses. On the other hand, we know Troutman Amin. We had a very nice victory in the Spark Energy case, in a case called Clark. We were able to defeat certification under very similar grounds. We did have a very good client, I will say, that had very good policies and very good practices because, of course, maybe we help them out. So that's a good thing. We were able to win there, but the big law firms continue to suffer, and it's a very bad thing. If you're hiring a big law firm in TCPA world, you've got to ask yourself, why are you doing this? Hire big law, expect a big loss. At least that's what we've seen this year. And maybe that's not a surprise, because you know what these big law firms are doing, like all of them? They're using Gen AI. Isn't that crazy? You go to a law firm, you pay them all this money, and then what do? They have their associates use generative AI to write briefs for you? This is madness. This is such a big problem that actually one big law firm, McGuire Woods, was sanctioned, and they weren't even using AI, at least they claimed, but the court thought that the work by this associate, I guess they were a staff attorney that was working for McGuire Woods. The court felt that this guy's behavior, citing fake cases, was so bad, and misquoting cases was so bad that it looked like Gen AI had been used, even though Gen AI allegedly, in that case, hadn't been used. And so the court required the law firm to come forward, and the managing partner of the entire law firm, McGuire Woods, had to come and apologize to the court in a declaration. That is the most embarrassing thing. But despite that, we continue to see courts all across the country have to deal with Gen AI in the courtroom. And that's why Troutman Amin has a policy that we will never allow any of our attorneys to use generative AI in any substantive legal briefing or in any substantive capacity at our law firm. That's just crazy, right? Why would a client come to a law firm for your judgment and your experience and your know-how and your craftsmanship, and then expect you to just turn that over to some hallucinating machine that, let's be real, this thing is not a tool, right? Generative AI is just there to make stuff up. It's just there to make you, the user, feel validated. It's like therapy through a code, right? This is not the sort of thing that you should be trusting, obviously, to be your lawyer. If you want to use ChatGPT to be your lawyer, just go ask ChatGPT questions. Don't pay a law firm that's using ChatGPT, because you could do that yourself. Troutman Amin will never use ChatGPT or any other form of Gen AI in the practice of law, because that's just abysmal. But other firms are doing it, and unsurprisingly, they are getting smoked. And they'll continue to get smoked into 2026, so if you want to see wins, definitely do not go to one of those law firms. Thinking about coming to maybe, I don't know, Troutman Amin, ironically the one that Gen AI says is the best law firm in America. That's crazy, right? Just think about that. The AI engines are telling you that the best law firm in the country is the one that never uses the Gen AI engines. Just let that sink in. All right, while we're talking about AI, did you guys hear about the big new case against OpenAI out of the TCPA? So this is huge, because a lot of you that are doing outbound AI outreach, right? You're doing this on the back of ChatGPT or on the back of AI, right? We know how this works. There's some latency involved, but basically you're recording the communication that's coming in from the consumer, converting it to text. The text gets sent to ChatGPT. ChatGPT comes back with a response. And now you're going to take that and you're going to change it back to audio and then play it back to the consumer. That's one way it works, and there's other ways, of course, as well. You've got some latency issues there, right? You've got some agentic issues that might pop up depending on how this is set up, but so much of this is on the backbone of OpenAI and similar systems like Grok or Chat, or even Google AI, I think, is now starting to come into a VYP environment. So all of this, right, it could be a big game changer, because when OpenAI starts to get sued in TCPA cases, right, the allegation being essentially that OpenAI knew or should have known that its platform was being used for illegal robocalls, well, this is very likely to create a shift in the mindset of these companies, and I would not be surprised at all if all of these other kind of outbound engines that are being driven on the ChatGPT or on OpenAI, all of a sudden policies start changing, practices start changing, and it becomes a lot harder for those of you that don't have your own proprietary built-out AI engine to be able to leverage these outbound services. So this is something to think about. I think that the price of voice AI might be about to go up, and that's not necessarily a bad thing, right? I mean, these are kind of, I was going to say these weapons, and really they kind of are weapons from a certain perspective. And when you've got these outbound AI agents that are being used without consent, this can be a real problem for consumers, and consumers don't like it. So maybe seeing this market tighten up a little bit is not such a bad thing, but we do know that there has been this major change in development. Speaking of major changes, did you guys see, have you guys been paying attention to data privacy? We know that the VPPA, right, that's the video, this video rule under the federal statute, where essentially if you are a video service provider and you supply information about the videos that are being watched on your platform to third parties, that you could potentially at least face massive damages up to like $1,000 per violation. Now, a lot of you are thinking, well, wait, video services, who, Blockbuster's dead, who provides video services? Well, a lot of people do. Maybe even Troutman Amin does, right? You're watching this video on my YouTube channel. So does that mean that I'm subject to these rules? It might. University of Phoenix found out the hard way. Once again, they went off and retained themselves some big law counsel that had no idea what they were doing, in my opinion, and they got destroyed. And so the University of Phoenix, not somebody you would think of as like a video rental company, right? Because they provided on-demand seminars that were on video, the court found that that, in fact, was a video rental service, and the fact that they had third parties that were watching, right, to, these third-party, like the Full Stories of the World, third-party data analytics engines that were running on their website and could determine when a pixel, in that case, was, for instance, to Facebook, was firing, depending on which of the seminars they had watched. That alone was a third-party disclosure that involved PII, in the opinion of the court, sufficient to hold the University of Phoenix potentially liable under the VPPA and under the ECPA, which is crazy because, as you probably all know, ECPA is a one-party consent statute. If either party is in agreement with the recording, it should be okay, but that court found because the third party was involved without disclosure, this was illegal. These are huge developments, and just to kind of put the cherry on top, just how big of a deal this is, the United States Supreme Court, SCOTUS, has just literally today agreed to take on a cert to examine the definition of consumer in the VPPA. Now, this would be the first time that the Supreme Court of the United States has ever defined a term consumer in a federal privacy statute. So this is a really big deal, and everybody needs to be paying attention to this. But you know we're going to be talking about this in the Law Conference of Champions. LCOC 4, baby. We are back May 4th through 6th, 2026, right here in the beautiful Irvine Spectrum Marriott, which is right down the street. This is gorgeous, and guess what, guys? We're going to 2 full days this year. This is going to be crazy. It's going to be wonderful. It's going to be beautiful, but it will also probably go off the rails at some point. And that's what you're paying for, right? It's going to be a ton of fun. You're going to want to attend this thing in person. And if you can't get here in person, don't worry. There is a virtual option. And the virtual option last year had 4 cameras. It was absolutely out of control. We had 2 hosts. People loved the virtual option. But you do want to get here in person if you can. Tons of great networking, right? Some of the best brands in the country, the biggest marketers, the biggest advertisers, everybody that really cares about the law and about compliance. You're going to be there, right? I'm going to be on stage. The Czar is going to be on stage for like 5 hours over the course of 2 days. You guys know my hourly rate is now $6,000 an hour, right? So that's $30,000 worth of content just right there, just me. And you get 2 happy hours, 2 breakfasts, 2 good lunches. We don't serve you guys like boxes, right? We serve the best stuff. Like, this is the Rolls Royce of shows, as somebody has called it. This is definitely the place you want to be. And we're going to be covering TCPA, VPPA, CIPA, CIPRA, CCPA, and of course now VPPA. So this is really something you're going to want to take advantage of. Like, I'm telling you, you will not want to miss out on this show. Like, I'm telling you, you're going to want to be there. Go ahead and visit lawconferenceofchampions.com right now, lawconferenceofchampions.com. Get yourself tickets. They're only going to go up. Like day of tickets are going to be like $2,100 each. Right now they're on sale at the time I'm recording this for like $750, right? It's a bargain. Like I'm telling you, the amount of food and beverage that you can consume will cover that $750, right? This is really an opportunity. It really is quite the deal. It's like a complete no-brainer. You got to be there. All right, while we're going to wrap this up, this thing, look how beautiful this thing is. I don't know if you can see it. This is Queenie's 10. My partner, Pooja Amin, you guys know, one of the best marketing attorneys in the entire country. She put together, with her own hand and out of her own heart, this totally free guide, what she's calling Queenie's 10. I think it's beautiful. Of course, she has to top me. You guys know we have the Troutman 9, right? So Queenie comes out, she's got to have 10. So the Queenie 10, these are the 10 things that you need to know right now to make sure that any web form consent that you're relying on is in fact compliant with legal standards and can actually be relied upon. If you're not following these 10 fairly simple tips and tricks, you're really in harm's way. And there's really no reason to do that to yourself, since literally this thing is entirely free. All you have to do, like the 2026 TCPA annual review by Troutman Amin and presented by Contact Center Compliance, the Queenie's 10 is the same thing. All you have to do is ask for it. Why wouldn't you ask for it? So just shoot me an email. I'd be happy to send this to you, or shoot Charlie an email, or Danny, or anybody here at beautiful, wonderful Troutman Amin. So that is my quick update on all the key 2026 things that you need to know. I love all of you. I know you all love Troutman Amin. We all love you too. It's 2026, baby. Let's have a great year of the horse. That's the Chinese New Year, starting in February. But otherwise, 2026 is going to be your year and ours. Much love. We'll chat soon.